Well, today I'm going to give a little tribute to specializations of prosecutors and the lack of feedback loops. Years ago, one of the guys with whom I practiced quite a bit and who used to work for me and I represented a member of the Hmong tribe in Vietnam, Laos. He was royalty, came here after the fall of Saigon, and frankly was a spoiled brat. There was a religious group, Latter-day Saints, that had their missionaries work among this group in order to get converts. And they learned the language, they learned the culture, they learned about the people, and they volunteered and helped them and counseled them. They also politically wanted to break down the royal structure and make the culture a little more democratic maybe, or a little more Mormon, or a little more family oriented. It all depends on how you want to define it, but there was a problem. And one of the problems was the culture. And the culture of the Hmongs were that if a single woman slept with a man, that was tantamount to a proposal for marriage, and that they would then get married in a formal ceremony. Well, there was this young lady, real pretty little lady, right off the boat, and was noted by this prince. And he invited her into his house and seduced her, essentially. Well, the missionary got a hold of her and said, "This is America now. You don't do that, and you should file rape charges against this prince." So the missionary led her to the district attorney's office, the police department, district attorney's office finally, and they went and arrested our client for rape. Now, technically, legally, it wasn't really rape. It was a strong seduction. But they were trying to establish different rules on so-called sexual assault. And the charge wasn't really rape. It was a sexual assault. And it was on somebody that didn't know any better, or somebody by a position of trust on somebody that would have been trusted, or who had the duty to trust toward, or whatever. It was essentially the young lady should have trusted the crown prince because he was a royal member of the royal family and her sovereign, and he shouldn't have taken advantage of her, essentially, was the prosecutor's theory. And they had just brought about specialists in sexual assault cases. And these specialists were essentially trained to enlarge the definition of sexual assault into various factors. And they were specialists, and they were set up for special test cases, and they were essentially crusaders also. So we get to court, and the only person they can use or find as an interpreter for one of the first hearings is the Mormon missionary. Now, we objected to him. We wanted a regular translator, but we didn't want somebody that was pushing or advocating the prosecution, and there were lots of things wrong with that. And the district attorney, in all fairness, agreed that we had a point, and they went and tried to find a Hmong interpreter, which they finally did. So a month or so later, we had our preliminary hearing. And during the preliminary hearing, this lady kept not wanting to testify. She wasn't responsive to either the prosecutor's questions or the interpreter's interpretation, and she seemed very out of it on the stand, I guess you would say. She kept nodding off, things like that. So the prosecutor finally called for a recess and discussed it with her colleague and the interpreter, and her interpretation was that because she was testifying against the prince, she was just too nervous to testify, and all of this kind of stuff. Now, that's not through the court-appointed interpreter, but that was the interpretation using the religious missionary as the interpreter. So, although she'd prosecuted many drug crimes, she decided that the woman witness, the young lady, needed a Valium to calm her nerves. So she supplied a Valium to the witness. Pretty soon, the witness just nodded off totally and couldn't be revived. Somebody called the paramedics. The paramedics came. They opened her blouse and was going to examine her, and there was a note pinned to her bra. And the note was passed around to the interpreters, and everybody started panicking. And the prosecutor wouldn't tell me what the note said, but we finally got it from the interpreter. And the note said she was humiliated, and her whole family was humiliated because she was being pressured into testifying against her sovereign. And it was disgraceful and disgraced her whole family, and there wasn't any way out of it because they told her she had to testify. And she decided to commit a suicide, and she'd taken a bunch of sleeping pills prior to the court in order to commit suicide, and they weren't working as expected, although she was dozing off on the witness stand, but probably the Valium put her over. In any event, they had to go pump her stomach and revive her and all this kind of stuff. Now, this, I think, is what's wrong with the specialization in the district attorney's office. And the specialization comes with the fact that they no longer look at us as professionals and recognize the common law view of attorney-client relationship and what the attorney-client relationship actually is. Instead, they view it as a mercantile relationship where we're selling a service or selling something to the public like any other merchant, and we're only hired for this job or that job, which isn't really the case. Those of us taking the oath of office prior know that it wasn't a matter of selling our services for a particular purpose. It was a matter of a relationship. And we entered into a relationship with our client, and the relationship was essentially forever until the client fired you. So we had this attorney-client obligation toward our clients, no matter what the job. And if the job was beyond our capabilities or whatever, it was incumbent upon us to recommend bringing in co-counsel or getting help or whatever, but it was still our client. Now, when they brought about advertising, they said we need specialists, and specialists essentially were administrators. We didn't follow the British model with barristers and solicitors. We would get people that specialized in that type of case, and they would be hired as an attorney for a one-time occasion, the same way as you'd go to the grocery store and buy a bottle of milk or a loaf of bread or whatever. So there wasn't any special attorney-client relationship or privilege except for as far as that particular case is concerned. So we had experts, and experts really didn't act as lawyers. They acted as facilitators or administrators. And if you look at what's going on in the court system today, you'll see that it's all administration. You walk into any courtroom and rarely will you see a trial going on because judges don't judge anymore, they administrate. They administer. Same way with public defenders and prosecutors. The game is to move as many files from the left side of the desk to the right side of the desk in as short a time with as least effort as possible. in any event, here we are with specialists, and we have this whole thing on multiculturalism. But multiculturalism to these specialists means dealing with Hispanics and maybe a few other people, but imposing our culture and our cultural values on them. So, for instance, if you have a custom of female circumcision, you determine that's bad and bad for the society, and you outlaw it and punish people. If you determine abortion is bad as a matter of social policy, you eliminate it. And you've got a whole bunch of people that want to eliminate everything that's, or not really look at real cultural differences, and essentially pay lip service to cultural differences as long as they sort of agree with our culture. But the Hmong culture was different because it was somewhat equivalent to the old slave culture of the Romans or the Greeks or various other people under feudalism. And this hotshot woman DA in Denver, who was a specialist on sexual crimes and sexual abuse, didn't really want to recognize that, or couldn't recognize it, or just acted out of ignorance. I'm not really sure what the situation was there, but whatever it was, she gave a volume to a woman who had tried to commit suicide by ingesting a bunch of dollars, and it damn near succeeded. Because she didn't approve of the custom, and she didn't approve of our client's brass, cavalier attitude towards sex and things like that. He did have probably what most Americans would call a shitty attitude toward women and sex, things like that. Chauvinistic, I think, is one word comes to mind. But the real problem is we put people like this in power that make decisions, life and death decisions sometimes, without really understanding, but feeling they have God on their side. They think they can do anything they damn well please. And there is no feedback loop. Nobody talked to that person about the fact that she nearly committed a homicide on her witness, and that maybe she was wrong because the social agenda of the experts in the DA's office took precedent over everything else. And if you look at the whole history of law, there's a lot of changes because prosecutors wanted that to be the law, particularly in the area of toy guns and things like this, but also in other areas. And I would think we should look at the whole cultural thing before we start making legislative changes. And we especially ought to look at the DA's role in policy making, how they make policy, why it's made, and things such as this. We should also look at their training. How are they trained? What courses are they given in conflict resolution? I probably have 35 hours or so of advanced sociology, including conflict management, postmodern social theory, etc. Various social theory. I'm a theorist. And one of the things I can state categorically is that the law is screwed up because you don't have people in the law that are schooled at common law. They're schooled to administer. Law school now puts out lawyers in order to assist multi-corporations who don't give a shit about law as such as a theoretical thing, but they want to know, can I do this or can I do that, and figure out a way of doing this, figure out a way of screwing that person, figure out a way of getting around this law, figure out a way of getting around that law. You can see it in the government. You see these memos, Attorney General memos, about you can do this, you can do that, and all of them are administrative and not theoretical about law itself. Nobody talks about equity, nobody talks about how law came from corpus juris, Saxon Spiel, things like that. They don't know the history, and they don't know the history. The fact they don't know the history really impedes their decision-making process. So they look at things as they are now. And unless it's not convenient for them. So they can claim that, for instance, gun laws were when guns were flintlocked. That's when when the right to bear arms was established, but we no longer have flintlocks, things like that. So we have to predict or interpolate what that means. And all the gun people of the Second Amendment are anxious to interpolate and interpret in modern day times, but something else like abortion, they're not. So it's a pick and choose thing because we don't have feedback loops. We don't have people saying this is right or this is wrong. The biggest feedback loop was the jury system, and they've tried like hell to abolish the jurors and juries because they don't like the feedback. Somebody says a marijuana law is unfair, they don't want to hear that shit. They don't want to revise marijuana laws. They want to put people away. They want to sell military equipment to the cops. So we ignore the feedback from juries, or we tell the juries that all they can do is determine the facts, which is totally against common law. And we've got people in power now that are misinterpreting, either deliberately or out of ignorance, all kinds of legal situations. And they shouldn't be. They shouldn't be in that position. They shouldn't have that kind of power. Corporations shouldn't have that kind of power. But most of the law now, and lawyers are turned out in order to be slaves or employees or whatever to corporations who often through lobbyists, etc., make policy and don't even realize they're doing it. And the policymakers have no feedback loop to say what they're doing is wrong or doesn't work. And so we're in a screwed up situation. It's time we should start doing an analysis, a functional analysis of how government works and how various other things work, and start publicizing that to the people rather than letting the government or corporations handle the whole information gathering and dissemination process. And we have to really start to look at that and start to regulate that and think about it. So that's enough of a rant now. I think with artificial intelligence making decisions rather than intelligent people, it's going to get worse because particularly without feedback loops, artificial intelligence really isn't intelligence at all. It's a way of saying this should be going on or that is right, this is wrong, without anybody having to say or having to think about it because people don't want to think anymore. So if you're making any sense out of this rant, I hope you would make a comment. Most of what I do is off the top of my head. I don't use an outline. I don't use a guide or anything. I get on a topic and I start thinking about it and start talking about it. And this is the product. Have a good day.